This is a third lecture on equity. We have already studied what is known as equity, and also we have seen what is known as common law, and we have seen the history of equity. Finally, we have seen the enactment or introduction of Judicature Acts 1873 and 75. In the equity, first of all, we have seen that equity is the base for the law of trust. The law of trust was born out of the equity focus. Then generally when we see or when we heard about equity, what is known as equity, simply we can say equity is something like fair, ethical, moral, and some extent we can say to achieve the justice we can use the equity. Then we have noticed or we have seen in the second lectures regarding the common law. What is known as common law? Earlier there were two different systems were in place. Then after Norman invasion, it was brought under one legal system. Scotland, England, Wales, all places, the whole United Kingdom brought under one legal system. That's why it was known as common law for the whole kingdom. Then we have seen the King Bench established by Henry II, and the determinations were given by those courts. That was the common law. When the person who aggrieved by the decision of these common law courts applied as a right to the king or made a petition to the king, then the king gave the decision in accordance with his conscience. Then because of the workload on the king, then the king appointed chancellor. Then again proliferation of suits with this chancellor, then the chancellery division, that means court of chancery established. That was one of the administrative division of the chancellor's court. Then we have seen after that, after all these divisions and growth, there were two recognized legal systems. One, the common law courts and common law system. Common law, that's known as common law legal system. And the other side, equity and court of chancery and equitable principles. Likewise here also, when you say common law, there were some common law remedies. Here also like equity and equitable principle and equitable remedies were there. Now the problem, there was an issue where to go. First of all, you must go to the common law courts. But the issue was there, if a person who wanted to get some sort of equitable remedy, then he must go to the court of chancery, not to the common law courts. Then the case initiated at the common law courts and stop there, then go back to the chancellery court, and whatever equitable remedies wanted, then you must apply there and get such relief. Then again come back to the common law courts. Then the people started wandering here and there for all the cases. That's why after Parliament reports, upon the submission of the Parliament report, Judicature Acts 1873 and 75 introduced. Actual purpose of Judicature Act establishing one Supreme Court of Judicature, that is single Supreme Court of Judicature to the entire country. Then the two systems brought under one single system. That's why here Judicature Acts 1873 and 1875 were responsible for amalgamating the existing Supreme Courts into single Supreme Court of Judicature. Then Supreme Court replaced so many courts as one Supreme Court, that is here. The 19th century was the period of great development of the equitable jurisdiction based upon the principles established by the end of Lord Eldon's tenure. The enormous industrial, international and imperial expansion of Britain in this period. Upon the introduction of Judicature Acts 1873 and 1875, the judges could deal with their work without fear of opposition of common law. The two courts had become not rivals but partners in the work of administrating justice. We have seen in the previous lectures also, there were two different systems. There were some conflicts. Then there's some sort of competition, because always Chancellor intervene anything and everything, because on the ground of conscience that we have seen. There was some sort of competition. Now there is nothing competition now at all, because both now brought under one. Then the two courts had become not rivals and partners in the work of administering the justice. The time had come for the fusion of these jurisdiction into the single Supreme Court. Some limited steps were taken towards this fusion in the middle of 19th century. The Common Law Procedure Act 1854 gave to the common law courts a certain power to give equitable remedies, and the Chancellery Amendment Act 1858 gave to the Chancellery Court the power to award damages in addition to or in substitution for injunction and an order to specific performance. That you have seen in what is known as specific performance in your law of contract. However, major change came with the Judicature Acts 1873 and 1875. These acts abolished the old separate courts of Queen Bench, Exchequer, Common Pleas, Chancery, Probate, Divorce Court and Court of Admiralty. It created Supreme Court of Judicature with the High Court divided into divisions known as Queen Bench Division, Chancellor Division, and Probate, Divorce and Admiralty Division. Later was renamed as Family Division in 1970. Its Admiralty jurisdiction was assigned to the Queen's Bench Division, and the Probate business assigned to the Chancery Division. Each division exercises both legal and equitable jurisdiction. That's very important here. This is a point I would like to emphasize here. Both divisions exercise both legal and equitable jurisdiction. Now, the amalgamation of administration of law and equity given to one body. Because of that, both institutions now brought into one, and also in the High Court level, there are two divisions. But whatever it is, when you see the exercise of power, especially legal or equitable jurisdiction or legal principles or equitable principle, that was brought under one roof. Thus, any issue can be adjudicated in any division at any point of law or equity. Then what we have seen here, any issue can be adjudicated at any division. That's very important point. Now, one Supreme Court, and there are two divisions in High Court. In all three, the main divisions there, in all three may adjudicate any cases. The cases in relation to the equitable claims or maybe common law claims. Whatever it is, they have the power to deal with. Then at any point of law or equity can be raised and determined by any division. Now there is no division at all. If the case before admiralty case or whatever, then the equity principles or common law principles may be applied. At the same time, the court has the power to give any remedy that may be sometime maybe in common law remedies or sometimes equitable remedies. But to the sake of administration convenience, cases were allocated in the division according to their general subject matter. Thus, the court the court is not a court of law or court of equity. There is no division. Now the court is not a court of law or court of equity. It is court of complete jurisdiction. Now we will move. This is an introduction given here. Now we will go to other slide here. Now the issue here, very interesting, that we are going to see. Whether the administration of law and equity fused or merged or mingled, or the law and equity mingled. Now we must see once again the administration of law and equity fused or the law and equity fused. That's the issue. Now we are going to see. The many academicians have distinct perceptions as to whether the Judicature Acts fused both rules of equity and common law to make them one, or whether it was just an amalgamation of two rules so that each of them retains its identity but administered by in the same court or by the same court. Now the clear-cut issue here, if the administration of law and equity merged and fused, that's in a way very clear idea, because by Judicature Act or by Judicature Acts 1873 and 75, now one single Supreme Court of Judicature established. It has the power to deal with common law reliefs of common law claims as well as equitable claims. And it has power to determine and give the relief whatever may be common law remedies or equitable remedies. That means the administration now merged or fused. There is no second word at all. It's clearly we can understand. But the issue is here now, whether the law and equity merged. That's we must see. The Judicature Act clearly fused administration of law and equity, that we have seen. The question is whether equity and law fuse. That's the thing I explained to you now. Then some scholars think that rules of common law and equity are totally fused and are thus no longer distinguished, while others perceive that the effect of Judicature Act to have been procedural. That's another argument. Some scholars saying that there is a merge, that means that's the law and equity merged. Some scholars argue that not the law and equity merged, but the administration of both merged. Now we will see, first place we will see fusion of administration and continuing distinction between common law and equity. Now here the cases given, the authority are given here below this PowerPoint presentation. All these cases and authorities supporting that only there is a fusion of administration, not fusion of common law and equity. The Judicature Acts clearly fused the administration of law and equity by the creation of the High Court of Judicature, exercising both law and equity, and gave supremacy to equity in the case of conflict. Now, the administration merged, but not equity and equity and common law. In that case, if there are inconsistencies, if there are conflicts, then what we should do? Equity must prevail. Therefore, the intention of the introduction of Judicature Act was to amalgamate administration of law and equity, not the law and equity. Now we see. A disputed question is whether that act or subsequent development of law and equity should be regarded as having effected the fusion of law and equity themselves. Now, orthodox view is that only jurisdiction have been fused. That's very clearly we have understood. Legal rights always remain legal rights. Equitable rights remain equitable rights. Through that, but administrated by one and only court. Then whatever it is, if you say that this is equitable claim, then that's equitable claim. If there's an equitable remedy, always that is equitable remedies. The orthodox view is that only jurisdictions have been fused. The changes made by the Judicature Act gave rise to no new cause of action, remedy or defense which was not available before. Professor Ashburn said that two streams of jurisdiction, though they run in the same channel, run side by side and do not mingle their water. Once again, Professor Ashburn said that the two streams of jurisdiction, common law jurisdiction as well as equity jurisdiction, though they run in the same channel, same one and only channel, that's the one Supreme Court of Judicature and High Court, in the same channel, but they run side by side and do not mingle their water. Never, equitable principles cannot mingle with common law principles. Common law principle never mingle with equitable principle. Thus, the legal rights remain legal rights and equitable rights remain equitable rights, though administrated in the same court. But other bills which were, now we have discussed in these lectures, other bills which were introduced prior to the Judicature Act would indeed have fused law and equity, but they failed. There are, however, statements by great judges to that effect that law and equity are fused. Lord Diplock stated that two systems of substantive and adjectival law were fused. Adjectival law fused. In some jurisdictions, in the recent years, contrary to the Lord Diplock's views, the distinction between law and equity has achieved renewed prominence. It is important to be clear as to what is meant by the claim that law and equity are fused. If it means that there is now no distinction or difference between legal rights and remedies and equitable rights and remedies, it can't be supported. If you say that there is no distinction between the legal rights and equitable rights, legal remedies and equitable remedies, that cannot be supported. It is still clear legal ownership is different from equitable ownership. That's why we are going to see in our law of trust topic that we will see different minor topics there. Now the equitable ownership and legal ownership. As we have seen in the previous lectures, A transfer the property to B, that's the owner of the trust, transfer the property to trustee for the benefit of beneficiary. Now who is the legal owner? B is the legal owner. Who is the equitable owner? Equitable owner. C is the equitable owner. Then always that is there. If you say that there is no distinction between equitable rights and legal rights, that cannot be supported. That's why here Professor Ashburn said that although equity and common law are streams of jurisdiction running through the same channel, they run side by side without mingling their waters. MCC proceeds incorporation case revealed the fact that the Judicature Acts intended to gain procedural improvement when it comes to the administering of law and equity. It was thus not to transform the existing equitable rights into the legal title or fuse equitable rules with the common law. Further, authority may be given here the legislation of 1925, which was based on the assumption that legal ownership is different from equitable ownership. Even now, in the trust ordinance here, when you see that it is recognizing legal ownership as well as equitable ownership. That's why in the example that I have discussed now, B is the legal owner, that's the trustee is the legal owner, beneficiary is equitable owner. Then in this case, in the case of China and South Sea Bank Limited, equitable nature of the duties of mortgagee has been emphasized, although in the other case, Midforth, it was said that whether the duty is expressed as a common law duty or as a duty in equity, result is same. But it is not correct, because in other case, in the case of Raja, the court said that results may not always be same. Some certain circumstances, the results may be same, not always. Then here the damages. All the common law damages and compensation in equity. Now, when you see the claims, common law claims and equity claims, and common law remedies and equitable remedies. We can list those remedies as well as claim. When you see the remedies here, first of all, when you see the common law claims, for example, breach of contract, negligence, and fraud, these are the claims. For these claims, what are the remedies available in the common law? Damages, common law raising, and money had and received. Then when you turn to the equity, what are the claims under equity? Breach of trust, tracing property, claiming property on insolvency. What are the equitable remedies? Compensation, specific performance that you would have studied there, injunction, rescission, rectification, imposition of constructive trust that we will study later, imposition of resulting trust that we will study later, and account. Now, when you see this one, when you see the remedies, damages is the common law remedy, compensation is the equitable remedy. Now come back to this target holding limited case. Here, all the common law damages and compensation equity share the requirement causation. They differ on remoteness and foreseeability. And that means what we understand from this case, there are two different laws. There is nothing known as one and only law, because equity is there, equity remedies are there. Common law is there, common law remedies are there. Then we can't merge both together. MCC proceeds incorporation case, whether an equitable owner could sue for the conversion. It was held that such owner who has no title at common law could not bring such action. Equitable owner, that's equitable owner in the sense, that's why we have seen in the example, beneficiary is the equitable owner. He can't file an action for conversion. What we can do is he can bring an action right in personam against the trustee. That's why here, that we will see later, we will study that part later. For the purpose of understanding, just I want to introduce that part. But here, therefore, if the equitable owner is not an owner, really speaking, he has no title. When you talk about this example, you would have understood that one. B is the legal owner, trustee, because author of the trust transferred that property to trustee. Then trustee is the legal owner. If there is a conversion or trespass or whatever it is, then who must file an action? The B, the trustee must file an action. Who is the legal owner? Equitable owner take action against the trustee, not in relation to the property, because that is the difference between equitable remedies and equitable rights and equitable claims and common law claims. That's why we have seen that equity acts in personam, not in relation to the rem. Right, now we will see the fusion of common law and equity. Now, up to now we have seen there's a fusion of administration of common law and equity. Now we are going to see not the administration, that administration also fused and merged. In addition to that, we say that here there are some scholars giving some opinion like fusion of common law and equity. There is no two different laws now. Now there is one and only. Some scholars and judges believe that Judicature Act did not merely fuse administration of law and equity, but rather fused the rules themselves. Now here, according to Lord Denning in Errington versus Errington, stated that rules of equity and common law has been fused for almost 80 years by the time. Now, Lord Denning clearly mentioning here, this is something happened more than 80 years time. Now, no point of talking that one because already everything is done and finished. Now in this one, what we are seeing, fusion of common law and equity. Now we will move to the next PowerPoint presentation here. Tinsley versus Milligan. In this case, the question was whether the equitable interest could be asserted in spite of an element of illegality in its acquisition. Lord Wilkinson explained that the legal and equitable interest had different incidents for historical reasons, but the fusion resulted in the adoption of single rule as to the circumstances in which the court would enforce the interest acquired under an illegal transaction. Thus, the rule is the same whether the claim is to legal or equitable title. Now, what is said here? Now, when you see here, what is meant by this judgment? According to this judgment, the historical they accept at earlier days. Explain the legal and equitable interest. Legal and equitable interest had different incident. had different incident. For historical reasons. But the fusion resulted in adoption of single rule as to the circumstances in which the court will enforce the interest according to an illegal transaction. Now the issue is, according to this case, the Lord Wilkinson explained that now there is only one law is there. Single rule is there. There is no equity and there is no common law. That's one is there. Because law and equity fused. Now, if you say that there are circumstances where you can get some sort of interest, there are circumstances where you are not entitled for such interest. Then what? Then if that may be an exception. Then you can't talk about whether it is equitable or whether it is common law. But you must see there is one. But there are circumstances. Maybe those are the circumstances maybe in equity. But you are not entitled. Sometimes maybe in common law you are not entitled. Sometimes in another way. You are entitled under common law, but you are not entitled to equity. But we don't talk about whether it is common law or under equity. But we will say there are circumstances under which that's entitled. There are circumstances where this is not entitlement. Right. That's the way we will decide. Now here, when we go to the next PowerPoint presentation, it was thus held that equitable principles that governs when the property or the title was affected under illegality had now become one after merging common law rule. Now that's the one thing. Sometimes it depends on the facts. Depending on the facts that may be given, the rights may be given, sometimes rights may be refused. In Napier versus Hunter case, in that case what happened? The judiciary's task nowadays is to view two strands authority, law and equity, mold into coherent one. That's all came into one shot. Now there is nothing known as equity jurisdiction and common law jurisdiction. Everything came into one, mold into one coherent things. Now see in this case, Aquaculture Corporation Limited case. This is a New Zealand case. It was stated that equity and common law are now mingled. Finished. Matter is over. Very clearly said that. Full range of remedies should be available as appropriate, no matter whether they originated in common law or equity or statute. That's one law is there. There is nothing known as common law, equity and statute. One law is wherever originated, doesn't matter. Now one law is there. Sometimes if they are entitled for remedy, the remedy will be given. If you are not entitled, that case will be dismissed. In Medforth case, I do not, in my part, think that it matters whether the duty is explained as common law duty or as a duty in equity. The result is same. That you can't accept. In other cases, they said not always, but we have seen. Results may be same in most of the cases, not always. Then these also given to say that now there is no issue at all regarding whether it is a legal right or equitable rights. Always we will see whether there is a remedy, maybe on the basis of equity or on the basis of common law. And this case Sembara Metal Limited case, what happened here held that compound interest may be recovered at common law as well as in equity. But what we have seen, 1 minute we must see again, the previous one we have seen, right in personam, right in rem. Right in personam is a right against the person. Right in rem is a right in relation to the property. Right in rem in the sense, right in person in the sense, now in the example that I have discussed now, B is the trustee, C is the beneficiary. Now suppose a trespasser enter into the trust property, then who must file an action? B must file an action because he is the person who has right in rem. Right in rem always with the person who has the title, legal title of the property. Legal title of the property. But equitable title with the equitable rights or equitable title with the beneficiary. Beneficiary can't file an action against the trespasser because the trespasser involved in relation to the property. Then the owner of the property, that's the trustee, must file an action that is right in rem against the trespasser. Then if the beneficiary wanted to file an action against this trespassing, then what he should do? The beneficiary should file an action against the trustee to compel him to take action against the trespasser. That's the equitable right. Equitable owner maximum, he can, as in equity, there's a right in rem. That's why we have seen equity acts in personam. Act in personam in the sense he can file an action against the person, not in relation to the property. Now in this case again, one of the example given here also, there are no two different things. Now there's one thing. That's why here in the context of limitation period, it has been held that there is no distinction between action for fraud at common law, action in equity for deliberate, dishonest breach of fiduciary duty based on the facts, which is equitable counterpart of the common law claim. That's the idea of the court. This is something like in anything and everything you can file an action. There is no difference between these actions. But confirm that in the other case, Swindle case, the Hophouse LJ confirmed that the common law damages were not available for breach of duty, breach of fiduciary duty. Because damages, common law damages is for the common law claims. If there is equitable claims, then it should be compensation. One indication of fusion is a situation where legal remedy of damages may be given for breach of equitable rights. Now that is an indication. Now we have set up to now. Damages is something like common law remedy. Compensation was like we have seen up to now is a equitable remedy. But here legal remedy of damages may be given for breach of equitable remedy. That's the indication of fusion. The converse, the equitable remedy for breach of legal rights such as injunction to restrain a tort or specific performance of a contract is explicable as the exercise of equity's concurrent jurisdiction is not example or fusion. Now we will move to next PowerPoint presentation here. Generally, the breach of equitable rights will provide equitable remedy only. Thus, a breach of restrictive covenant by a non-contracting party is remedied by an injunction, not by damage. Now, this distinction between the equitable remedies and common law remedies always there. It is there always. Right? In the other case also we can see that the damages are available for breach of confidence despite the equitable nature of the wrong. Now finally, what would be the conclusion? Now we have seen up to now, there are rare cases, there are authorities to say that administration of law and equity merged. And we have seen that's clear idea. Administration of law and equity fused or merged or mingled, there is no doubt that's done. That's clearly idea. But the issue is here whether the law and equity fused. There are authorities. We have supported now so many authorities in the PowerPoint presentation. I have given so many authorities supported to say that, to effect that law and equity merged or fused. At the same time, I have given some more authorities and supported cases and decided cases and jurist opinion saying that or effect that law and equity never merged. Now come to the conclusion. Both views are supported by authorities and strong justification that lot of confusion as to which side is right occurs. Then what to do? However, the rules of equity and common law are clearly administered in one court. That's clearly we have seen. That is the Supreme Court of Judicature. Even the High Court level, there are two divisions. But whatever it is, that is for administrative convenience, not for anything else. Then here what we have seen here, even though there are so many authorities cited both sides, the issue here we must decide what is the correct thing. Law and equity are clearly administered by one court. That's no doubt. Then this is to mean that although not entirely same, the rule of equity and law at times apply interchangeably. In certain cases like that, you can take it from there and apply, or you can take it equity matter, you can take it common law and apply. In the common law matter, you can take the equity principles and apply. That can be done. We have seen compounded interest. Compounded interest is in common law as well as equity. Then you can take it equity principles and you can apply, or you can take common law principles and apply. Either way you can do it. But that's why here we say that is to mean that although not entirely same, rules of equity and common law at times apply interchangeably. This perception accrues from the observation that Judicature Act does not authorize substantive fusion between law and equity. Neither does it reveal any prohibition for the occurrence of such fusion. Then the Judicature Act does not authorize such fusion. At the same time, does not prevent such fusion. Therefore, the time will answer. Now, for the purpose of what we have studied now, briefly we will see what we have studied up to now. First we have seen the fusion. Fusion in the sense, briefly when you see this one, the Judicature Acts 1873 and 1875 introduced. The purpose of these Judicature Acts was to administer the justice system under single rule. Because of that, the Judicature Act established single Supreme Court of Judicature, and also even in the High Court level there are two divisions, but it is for administration convenience or convenience. Now what we are seeing, whatever said and done, when you see the ultimate purpose of this Judicature Acts, these Judicature Acts was to amalgamate or merge the system or administration of those two, equity and common law. When you see this one, when you read the Judicature Act 1873 and 1875, there is no provision in relation to the fusion of equity and common law. If there are conflicts, then equity shall prevail. That was provided. That means always in the law level, we must see there must be the grassroots level, there must be equity as well as common law. Those equity and or equity or the common law never merged, but the administration merged and done well. Now, because of these equity principles, from time to time, incorporated or accommodated into the common law. Once the equitable principles accommodated into the common law, that will be recognized as common law, not as equity. For the time about 1,000 years time, or simply say about at least 700 years period, there are so many equitable principles accommodated into common law. Because of that, now we don't know whether it is equitable principles or common law principle. Then when you take something, it may be equitable principle or maybe common law. In those cases, the judiciary decided that there is nothing known as equity and common law. That's one thing is there. We will take one thing and apply for the problem and sort it out. Therefore, finally we will say administration of fusion, administration of merge, administration of law and equity merged or fused, but not that law and equity, even though there are some authorities given to that effect. Thank you very much. Now we will see another lectures on in relation to the nature of the equitable rights. Thank you very much.